Hello, everybody. We have a house full of very confused and slightly unhappy paw pets. They don't know what to do about all this snow and freezing rain and ice that we're getting from Mother Nature and Father Time. I think they're getting a divorce because they're both quite angry right now. They need to make up. I don't think we're going to get the 18 inches that was originally projected. But what we're dealing with right now is like expected 45-mile-an-hour winds, from what I hear. And I wouldn't doubt it. So there's lots of drifts. And there's more snow to come. So far, it's snow on top of a layer of ice. That makes taking Ava out extra special. So, yeah. Hello, Wisconsin. Hello, Jerry Matthew Boyd. Hello, C-Rex, my Midwestern friend. I know you feel my pain. Hello, Eileen and Carlin. Hello, Nana Laura, my love. Hello, Jenny Green. Hello, Joey Big Donuts. Well, at least you're warm in the truck. Hello, Iron Mother. Hello, she's a maker. 58, that's shorts weather. That's good stuff right there. Hello, Manuel. Hello, Charlie. And I'm so happy you are. Yeah, it's the princess. Hello, Salty Buddha. Hello, Mark Addy, honey. Hello, Ava's biggest fan. And a special hello, Riley. Hello, Shonzi. Yeah, my neighbor was out cleaning off his deck, and I made some comment about, hey, this is all your fault. You're the one that wanted this stuff. And something about he was going to be up all night shoveling snow. And he's like, no, I got to go back to work tomorrow. My vacation's over. He sounded a little defeated. Oh gosh, guys. I found some good stuff. Yeah. I like it anyways. And I bet you're going to like it. Well, I don't have to go anywhere to work, but I work. In fact, I'm gonna have to take a couple of days to do the dreaded taxes thing because I am terrible about keeping track of stuff. I am just, it's not my thing. So I need to create a spreadsheet with a drop down menu that I can put categories in. And that part I can do. I've done that before. The part that I struggle with is creating the formulas to make the spreadsheet add things like from the categories. That's what I'm going to struggle with. So if anyone has some spreadsheet making knowledge and wants to spend a day with me, because it might be a day, to help me get this thing made, and then I can input all of the stuff myself. It's just making the formulas and stuff and actually getting them to work. I am not very excellent in Excel. But see, I have to calculate all of my expenses myself and then provide the totals of my expenses to my tax guy. He says I can keep all the receipts since I have those, and if I get audited, I can just provide them. Okay, fantastic. But that means I have to calculate everything. And then he'll do the rest. Oh, that would probably be exceptional. But I'm not that savvy. Oh my goodness. I've got software expenses, hardware expenses. Like I have to pay for my editing program, the streaming program. I have to pay for the premium YouTube, which is a necessity if you're a streamer. Then there's the merchandise stuff that I had to get, you know. Actually anything to do with the animals, I can write off. I can write off a certain percentage of my home. Yes, baby girl, you were just out. You do not need to go back out. So there's a lot that goes into it. My computer, that's going to be a total write-off since the only thing I use it for is this. Part of my phone. Yeah, there's a lot. There's a lot. But that's going to be absolutely necessary because if I don't claim all of those expenses, Uncle Sam's gonna have me. Oh, yeah. The Wi-Fi, because that's like 98% for this. So, yeah. Well, boo. That does not help me. I have made spreadsheets in the past for other people, working spreadsheets, you know? But for myself, I just can't get it. Oh, I have to file because I make an income. I get paid from Google. I'm technically employed by Google. So I do have to claim it. They send me the 1099s and everything, and Uncle Sam wants their cut. I don't have to claim my disability, but I do have to claim everything outside of disability, which is fine. It's fine. I'm like that dog in that meme with the flames all all around. This is fine. Well, how do you know? No, no, I'm definitely not. Um, but um, I'm the house sold right before the end of the year, so I'm pretty sure I'm gonna have to file for that reason. Plus, I own my home. I have to file because I'm a homeowner. There's, I mean, I don't want to get on the wrong side of the IRS, all right? And when they do all of those like stimulus checks and things like that, the list they go off of is people who have filed taxes. Now, I know I'm going to get a refund because I have spent more than I've made. And that's just the God's honest truth. With all of the expenses that I have per month, um, especially with the computer. I mean, that was a big purchase. But yeah, I've spent more than I've made, which is okay because I love it. And someday it won't be that way. I do this for me. I mean, for you guys too, but I do this because I love this. And I love spending time with you guys. I know that sounds absolutely batshit crazy, but but nobody ever accused me of being sane. Oh, hello, Spider-Man. Hello, great granny. My parents passed away. So I was the executor of the estate. It's not completed because the probate still has to go through my father, because neither one had a will. But the home sold under my mother. All of the debts were in my father's name. So the home has to be transferred, or the revenue of the sale has to be transferred into an estate of my father, and then all of the creditors get paid out of that estate. It's a mess. Thank God I got a lawyer. He's handling it all. Lord knows I couldn't do it, especially after that case last night. That was kind of reminiscent of my family matters. Not quite that bad. You guys are my social interaction. When I first started doing this, there were a lot of people that would call this their therapy session. And it's still said every once in a while now. But yeah, we get together, we hang out, we have a great time. You guys make me laugh. Oh my God, you make me laugh. You make me happy. And if I make something out of it financially, that's just a bonus. But it's not my goal. My goal is just to hang out with you guys. So it gives me something to do. I'm very limited. After the accident, I lost literally everything. And I had to build a new life. This is my life. This is what I've chosen. I feel like this is my purpose, as silly as it sounds. This is what I was meant to do. Some days, yeah, yeah. Right. Well, at least for the first few years. Yeah. I don't see it as a bad thing. I know it'll balance out at some point, and at another point, then, maybe I will make something that I can live off of. That'd be great. I would love to not be on any kind of assistance at all. I would love to be able to afford my own medical care or whatever, you know? I can't though. Oh, Jerry. Jerry, Jerry, Jerry. Why don't we start with your childhood? They are my therapists. Yeah. Right. Facts don't care about your feelings. Right. Yeah. Yeah. But I think that's kind of another thing that bonds us. I mean, yeah, we enjoy watching court cases together, but I mean, we're all a little bit broken. A little bit broken and a whole lot beautiful. I'm sorry. Do you need to borrow Billy? Do you want to borrow Billy? I'll loan him to you. I won't even charge a fee. Dag nabbit. Hold on, I gotta get this. Oh, fiddlesticks. God, that floor gets farther and farther away from me every single time this falls. I have 4. Earl was here earlier. He's now just outside of the threshold. Bandit's in her room, and Tiny Kitten Esquire is probably hiding in the basement, because Billy's inside, and Billy doesn't like Tiny Kitten Esquire. So if she's not here before Billy comes in the room, then she's hidden. Oh, that's what you meant. Yeah. Billy's a chunk. He's 17 pounds. Well, he was when he went to the vet. I have been limiting his treat supply. He's not happy about it. But I'm hoping that it'll help him lose weight, because he really is a big boy. I mean, he's a big boy. I love you though. Okay, you can look out the window. I'll leave you alone. I'm sorry. Don't be mad. Don't be mad. Don't you swat at me. I love you. Yeah, true that. Yeah. No, I better just keep him here. I did. I gave her 3. And now she's under the desk licking her paws. Yeah, yeah. Orange boys have lots of energy. No, Manuel, what is your obsession? Oh, please don't lick my knee. Oh, Ava. Ah, stop it. Come on out. No, come on out. No, I draw the line. I don't like getting licked by dogs. It just I don't. Nope. I don't like getting licked by dogs. even though it's Ava and I love her, I'm just not into dog kisses. Look at that tail go. What are you hunting? What is over there? Should I be concerned? There's nothing. There is nothing. You are just scoping out the joint, huh? Get it, Billy, whatever it is. Get it. Oh, okay, you guys. I'm gonna put the cases on because they are fantastic tonight. At least some of them are. Some of them are meh, but they were. Well, I give her kisses and I'm fine with that. I give her kisses on her face all the time. On right here. Yes. Okay, here's the thing. I clean her water bowl, and there's always that dog slime. Okay, I can't handle that. They call it microbiome. It grosses me out. And I know it comes from dog mouth, you know? It can be improved with better dog foods. But apparently whatever I'm giving her, it's still slimy. And it's so gross. And then you see the dogs that have the big pockets of drool just hanging down their face, and they shake their head and the drool's just going like that. No. No. It's a secretion. It's I can't. I've never had a problem with it. I've never had the microbiome film from the cats. Maybe they eat better. I don't know. Maybe my cats are just special. I can give cat kisses. I can get kitty kisses all day long. I don't feel slimy when they're done kissing me. Heck, I'll even share my ice cream with my cats, if they wanted to. I don't have a problem with cats. I love cats and I love dogs. But I cannot handle dog mouth. Puppy breath is cute. I love puppy breath. But I don't want their tongue on me. Yes! Hello, Squishy. I told you, great granny. I told you. Yeah, now you see my perspective. Oh, come on, computer. There we go. Y'all ready for this?
All right, then. People of the state of Michigan versus Brian Darrell Spera. Mr. Spera appears this morning along with his attorney, David Kivisari. The prosecution does not appear this morning of their own choosing. We're set for a sentencing hearing. Did you have a chance to go over the recommendations with Mr. Spera, Mr. Kivisari?
I have, Your Honor.
Is there anything of a factual nature that appears inaccurate?
No, Your Honor.
All right, then. In regard to the matter, is there anything you wanted to say in general on behalf of Mr. Spera?
Yes, Your Honor. I'd just like to highlight that when he's not, making the type of mistakes that have brought him in here and also brought him in to a court in Minnesota, he's a very hard worker. He's a productive member of our society in that regard. I believe that the recommendation for 60 days is probably based on recent events, including that conviction in Minnesota in October. But I do think that the 20 days jail now, I would just ask for a minor deviation from the recommendation, keep the 1-day credit. And then 15 days now, I think is a bit more reasonable than he would have to have 90 days on the sober link. And I believe a full 3-month period for him to stay sober, if he can, would really benefit him.
If he can? That's an interesting choice of words.
In this case, I believe that he should be allowed out to continue to work after about a 2-week period, so he can get back to making money he needs to get by. Other than that, Your Honor, I understand all the other recommendations, and that would be the only deviation I'd ask for.
All right, thank you. Did you have a chance to look at the alcohol assessment? We did receive
I
it.
did, Your Honor. There's really nothing to it. It simply says that Mr. Spera does not have a substance use disorder.
Sure does. All right, thank you, Mr. Kivisari. Mr. Spera, anything else you'd like to say?
No, Your Honor.
Well, Mr. Spera, I think absolutely useless substance abuse assessment. They're only as good as the information you give them. And obviously you were not truthful with them at all. You have no previous treatment experience. That's what the report says. You've never been in any kind of substance abuse treatment before. Is that correct?
Yeah, 7 years ago.
So why did you tell him you have no previous treatment experience?
I didn't tell her that.
That's what the report says. You told him that you have abstained from alcohol since the incident in August. Do you remember telling her that?
Yeah.
And was that truthful?
No,
No, not at all. And why did you say that?
because I drank. I got arrested.
Right. So when you go have a substance abuse evaluation, didn't they tell you you need to be truthful with your responses?
Yes, Your Honor.
So what good do you think this substance abuse evaluation is?
I've been sober since then because I've been on an ankle monitor
For who?
for Minnesota
Since when?
since October 8th.
So there were aggravating incidences and factors, it says in your arrest report. What were the aggravating factors in that arrest? Do you know?
What do you mean, Your Honor?
Well, it says here in your criminal lien history, 2nd degree driving while impaired, 2 or more aggravating factors. DWI, operating motor vehicle under influence of alcohol, severity, other gross misdemeanor. Do you know what your aggravating factors were?
No, that I was drinking.
What was your blood alcohol level?
0.15.
In regard to the matter, then, I don't think the recommendations regarding the substance abuse evaluation have any indication that there was any truthful dialogue between the assessor and Mr. Spera. This is his fifth offense. Fifth. And there is no indication. He's telling him he's got no previous treatment experience. Just in this court alone, he was referred to Prime for Life. He was in Indianapolis. Did you forget that?
No, it was there's over 7 years ago.
So anyway, you can only get as good with your substance abuse assessment as the information you give them. So if you lie to them, then the result is not accurate either. You purposely lied in respect to, you omitted the fact that you got another arrest. You told him you hadn't drank since August, and you did that all so you looked better, in a better light. But here, going back, you got an OWI starting in 96, another one in 15, another one in 16, another one in 23, but from Michigan to Minnesota to Georgia. You're a menace on the roads all over the United States, Mr. Spera. So, and then the activity that you and your co-defendant engaged in, really, you're how old? 50, 51?
52, Your Honor.
52. I think you need to run back to kindergarten and pick up some basic principles on how to interact in society, Mr. Spera, along with some alcohol assessment and training. This is ridiculous. This is not an accurate assessment because you were not truthful, Mr. Spera. So this is what I'm going to do in respect to your case. You're going to be placed on probation for 9 months for the reasons being, this is his fifth offense, as I stated. The alcohol level in this case was a 0.11. He got another one shortly thereafter, plus 3 priors. He needs to be supervised for a period of time to make sure he's not a danger on the roads to the citizens of this community any longer. Fines and costs are $590. There's a $300 oversight fee for probation, if I didn't say that. Prosecutor's fee is $75, $100 in restitution payable to the Michigan State Police. Crime fund fee is $75. The justice system assessment fee is $50. That's $1,190. In regard to the matter, how does he intend to pay that?
He has it with him today, Your Honor.
All right, I'm going to order that that be paid in full today. I'm going to order 60 days in jail, 20 days now with credit for 1 day served. If the jail will allow you work release, you can have work release, but I don't think the sheriff is offering work release. 40 days will be suspended on the following condition. First, you're going to test now. If you test positive for any controlled substances, alcohol, do you have a medical marijuana prescription?
No, Your Honor.
All right, so if you test positive for alcohol, marijuana, or any non-prescribed controlled substance, your option for the 80 days on the sober link, as opposed to the 40 days suspended, will be gone. And you will serve the entire 60 days in jail with credit for 1 day served. Based on the recommendation from the assessor, they were recommending alcohol highway safety program. We can do one of two things. I mean, they're going to order him into outpatient treatment based on his lies, or he can have another assessment and he can be truthful with them and see what he's recommended, which is the preference.
I'm sorry, Your Honor, could you touch
Either
on?
I'm going to give him outpatient treatment based on the fact that the recommendation for the alcohol highway safety program is based on a whole basket full of lies. So either he can do outpatient or have a new assessment where he tells them that this is his fifth offense.
Okay, what would you, I think you can do that, right?
Yeah, we do. this.
Another more truthful assessment?
Yeah.
All right, we're going to order another assessment within 30 days of your release from jail.
Not a more truthful assessment. A completely truthful assessment. Let's go for that.
You have to follow the recommendations from the assessment. Going to order that you attend and complete 12 smart recovery sessions. During the term of your probation, you can go over that with your probation officer. Those are online. In respect to the matter then, In addition to the general terms of your probation, the following are specific to you. You must absolutely abstain from the possession or consumption of alcohol in any form whatsoever. You may not use, possess, or consume non-prescribed controlled substances or prescription medicines that aren't prescribed to you. You have to avoid all people that use, sell, or possess those items. Medicinal and recreational marijuana use and possession are prohibited until or unless further order of the court. You are subject to random PBTs and drug screens consistent with the order and the agreement of the parties. Your firearm and the ammunition are forfeited. Do you understand the order of the court then?
Yes, Your Honor.
All right. So in regard to the matter, Mr. Kivisari, any questions?
No, Your Honor.
Do you understand the appeal rights that you have, Mr. Sparrow?
Yes, Your Honor.
All right, good luck to you, Mr. Sparrow. Good afternoon, then, Mr. Adequately.
What was that,
Can you
Your
hear
Honor? You were coming in and out on the audio.
That's all right. I was just wondering if you could hear me adequately.
Now I can.
All right, good. All right, we'll call the matter then of the people of the state of Michigan versus Joseph Louis Gerwig, 237768 SM. Mr. Gerwig appears from the Dickinson County Jail along with his attorney, David Kivisari. The prosecution does not appear this afternoon of their own choosing. We're here for arraignment on a bond violation. Concerning the matter then, Mr. Kivisari, did you go over an advice of rights for a bond violation with Mr. Gerwig?
Yes, Your Honor.
All right, do we have that? All right.
Your Honor, I just handed it to a deputy here. He's going to fax it to you.
All right, then. Did you explain to the contents to Mr. Gerwig then, Mr. Kivisari?
Yes, Your Honor, I explained to him the basic factual basis for the alleged violation. I did.
And did you explain to him what the maximum possible penalties are for the bond violation?
Yes, I did, Your Honor. I explained to him that he could be facing 93 days in jail and up to a $7,500 fine.
All right, then, does he waive the formal reading or shall I read it aloud?
We waive the formal reading, Your Honor.
All right, and am I assuming I'm entering a not guilty plea on behalf of Mr. Gerwig?
Yes, Your Honor.
All right, Mr. Gerwig, your full legal name, please.
Joseph Louis Gerwig.
I do have in front of me that bond violation arraignment waiver form with your signature. Did you understand all of your bond violation hearing rights as explained by your lawyer?
Yes, I did, Your Honor.
And you understand all of the rights in the form that you signed?
Yes, I do.
All right, then I'm going to enter a not guilty plea on behalf of Mr. Gerwig.
This is his arraignment. He seems to be slightly pickled still.
We'll set the matter for a bond violation hearing as follows.
Bond violation hearing will be January 17th at 1:15 p.m.
Does that work for you, Mr. Kivisari?
Yes, Your Honor.
All right, in regard to the matter, did you wish to be heard on bond?
Your Honor, I would just ask that Mr. Gerwig be released pending the hearing on the 17th on whatever terms the court deems reasonable. It's difficult for me to interact with him if he's in here, and I really would like to be able to see him on a daily basis so that we can prepare for this adequately. So I'd be asking for you to just set a reasonable bond and allow him to leave today.
Just a moment, please. Let me see, maybe it says the result of this one. Oh, yes, all right. In regard to the matter then, for the record, the charges currently pending against Mr. Gerwig are false report of a misdemeanor in that the allegations are that he intentionally made a false report of the commission of a misdemeanor domestic violence to a 911 operator, knowing that the report was false. That was on or before December 23rd of this year, with the alleged victim in that matter being Tracy Oliver. As a result of the matter, bond conditions were established by the magistrate and included no contact orders, no harassment, etc., with Tracy Oliver and 2 other individuals, along with multiple other conditions, including no alcohol provision. I went over that advisal with him on January 3rd. I went over the fact with him that if he violated a condition of his release, he was subject to arrest without a warrant, and he could have his bond forfeited or revoked and new conditions of release imposed. Mr. Gerwig assured me on the record on January 3rd that he understood those conditions. In regard to the matter, here we are on January 5th, apparently 5 p.m. as reported on January 6th. The allegations are that he committed a bond violation for having contact via Facebook with the individual that I told him to stay away from, as well as registering a .107 on a breath test. So basically getting drunk and going back at it with the person I told him to stay away from. 2 no-nos. And that was 2 days after I went over it very, very carefully with him on the record. He posted bond on the underlying charge. A pretrial by mail was set. We're presently set for a jury trial on April 1st. In regard to the matter, then, is that trial date still open on, when is that? That February, the next day?
The 6th?
Yeah, yes. Did it get filled up? What does your calendar look like on February 6th, Mr. Kivisari?
I don't know, Your Honor. I hadn't had the opportunity to bring anything in with me.
All right. In regard to the matter then, is Mr. Kivisari here on any Friday coming up soon? Or any day at all for that matter?
I'm not seeing.
Not this Friday.
He's here on the 11th. He's here on Thursday.
Okay, at 9.
Yes.
And how does 8:30 look that morning?
I have an 8:15 with Judge Powell.
On a summary dispo? Yeah, we could do probably 8:45 safely. All right, this is what we're gonna do. We're gonna enter a not guilty plea on the bond violation. And we're gonna set the matters for both a bond violation hearing and a supplemental pretrial on Thursday, January 11th at 8:45. You're gonna be here at 9 o'clock anyway, Mr. Kivisari.
Okay.
So we'll just move that off docket, but the reason being, in regard to this April trial date, I would like to set February 6th as a trial date. I am revoking his bond. He's not going to be released pending at least next week. And we'll see about that. Maybe a couple of days in the old clank will get Mr. Gerwood thinking a little better about what I warned him about just 2 days before he went out and did exactly what I told him not to do. So, Mr. Gerwig, you made your own bed here. So he's gonna stay in jail. I guess you're gonna have to get creative, Mr. Kivisari, like every other attorney that has a client in jail, and figure out how to meet with them via whatever method. But he made his bed. But I'm gonna set a supplemental pretrial so we can have a realistic talk about, 1, when we're gonna try this case. And 2, we'll do the bond violation hearing as well. That is the 11th. That's Thursday, the 11th.
At 8:45.
At 8:45.
Yes, Your Honor.
All right, so that's just 3 days from now, and we can talk about bond again at that point, but right now, he can stay there. Mr. Gerwig, you got to think better.
I will,
All
Your
right.
Honor.
All right, Mr. Kivisari, anything else on this file today?
No, Your Honor.
Thank you.
Thank you.
Can we go off the record?
Off the record.
Time.
David, with your jacket.
Oh, right.
So
Sorry about that.
30 days and then I got quarter done.
Yeah, quote again in a couple. All right, Joe.
Right.
Now we get to go to the next hearing. We have 3 of them.
All right, there we go. We're live streaming this morning. People versus Joseph Louis Gerwig, 237768 SM. Mr. Gerwig appears via video Zoom from the Dickinson County Jail. His attorney is David Kivisari, who is present here in the courtroom. The prosecution is here through Chief Assistant Prosecutor Christian Cass. We're set for a bond violation hearing and a pretrial this morning. Good morning, counsel. All right, in respect to the bond violation hearing, then are we ready to go? Where are we at with that?
We reached an agreement, Your Honor.
All right, then who would state the terms for the record, please?
I can, Your Honor. In exchange for an acceptable plea as charged to the false report of a misdemeanor file, the people have agreed not to object to a request for non-jail. And by entering the plea today, we've agreed to dismiss the bond violation.
All right, has she correctly stated the terms, Mr. Kivisari?
Yes, Your Honor.
Mr. Gerwig, did you hear Ms. Cass state the terms?
Yes, you did, Your Honor.
And did she say them correctly as you understand them?
Yes.
All right, sir, what's your full legal name, please?
Joseph Louis Gerwig.
All right, Mr. Gerwig, I have in front of me then an advice of rights and plea information form. It appears to have your signature. Did you go over that with your attorney before you signed it?
Yes, I did.
All right, Mr. Gerwig, do you understand you have the absolute right to have a jury trial in your case? And in some instances, you have a right to a trial by court. Are you aware of that?
Yes, I do, Your Honor.
All right, are you aware then if you chose to have a trial instead of entering into this agreement with the prosecution, you could exercise each of the trial rights that are listed in the advice of rights form that you signed this morning?
Yes, I
Are
do,
you-
Your Honor.
All right, thank you. In respect to the matter, then the charge is false report of a misdemeanor. The maximum penalty for that offense is up to 93 days in jail and or up to a $500 fine. Mr. Gerwig, there could also be potential what are called collateral consequences. Excuse my computer screen here. Collateral consequences are things that happen on the side. For example, as a result of this conviction, you could have difficulty entering into a foreign country. Or if you're not a citizen of the United States, a conviction could result in removal or deportation from the United States, exclusion from admission to the United States, or the denial of naturalization. Do you understand then the nature of this charge and the maximum penalty, Mr. Gerwig?
Yes, I do, Your Honor.
To the charge, then, what is your plea?
Guilty.
All right, Mr. Gerwig, before I accept your guilty plea, I want to make sure that you understand the rights you're giving up by pleading guilty. Do you understand then by pleading guilty, there is not going to be any type of trial in your case?
Correct.
All right, do you understand then you give up all of the trial rights listed in this form you signed this morning?
Yes, I do, Your Honor.
Do you understand the court is free to impose any sentence that the court feels is appropriate up to the maximum provided by law?
Yes, I do, Your Honor.
Mr. Gerwig, understanding that and the other things I've gone over here with you, does it remain your intention to plead guilty?
Yes, I do, Your Honor.
All right, then, has anybody promised you anything other than what's been stated on the record this morning in order to get you to plead guilty?
No, Your Honor.
Has anybody forced you or coerced you or threatened you in any way to get you to plead guilty?
No, Your Honor.
Has anybody told you the courts would simply be more lenient with you if you pled guilty?
No, Your Honor.
Are you pleading guilty freely, voluntarily, and understandingly?
Yes, Your Honor.
Mr. Gerwig, the complaint indicates this activity occurred on or about December 23rd of 2023 in the city of Iron Mountain, County of Dickinson, State of Michigan. Do you agree with that?
Yes, I do, Your Honor.
All right, the complaint said that you made a false report by a 911 phone call of a domestic violence incident at your ex-wife's home. Is that true?
Yes, Your Honor.
And so what did you say happened at your ex-wife's home?
There was yelling going on and I could hear it, and basically I wanted someone to go check it out.
Well, the complaint also said you were upset with your ex-wife because she's dating somebody else. Is that true?
No, Your Honor.
All right, so I don't understand then, if you legitimately thought there was an issue going on and her safety was at hand, then it wasn't a false report. How was it a false report, Mr. Gerwig?
Because she always told me that she wanted me and not him. And she wanted him out.
So you told me that you thought there was yelling and screaming and you wanted the police to go check it out. That's what you said.
Yes,
All right. So did you know there was in fact no domestic violence going on when you made that statement to the police?
correct.
So you just wanted them to go over there because you were angry with her because she didn't want you anymore.
Correct.
All right. So you intentionally made that false report of a domestic violence incident, knowing it was not a true critical domestic violence happening. Is that true?
Yes, Your Honor.
All right. All right, I think that's a sufficient factual basis.
I agree, Your Honor.
How about you?
I agree as well, Your Honor, and having listened to the call, the transcript of the call, I would say that there was no indication that he had, you know, that he was an eyewitness to anything. And he used a false name as well.
All right. All right, then, in respect to the matter, do you have any objection to what he stated, Ms. Cass?
No, Your Honor.
All right, then, I think that there is a sufficient factual basis as well. Counsel, is either one of you aware of any promises, threats, or inducements in order to get Mr. Gerwig to plead guilty that have not been placed on the record at this time, Mr. Kivisari?
No, Your
How
Honor.
about you, Ms. Cass?
No, Your Honor.
And does counsel believe the court's complied with the taking of pleas under Michigan Court Rule 6.610? Mr. Kivisari?
Yes, Your Honor.
Ms. Cass?
Yes, Your Honor.
Thank you. Mr. Gerwig, I'm going to find you've made out the elements of the offense. I'm also finding your plea today has been made freely, voluntarily, and understandingly. I'm going to accept your guilty plea and find you guilty of that charge. Now, we're going to set a sentencing date. Probation is going to make a pre-sentence report that'll come out in writing. Mr. Kivisari will get that. He will go over that with you prior to sentencing. What are we looking at?
February 8th at 1:30 PM.
Does that work for you, Mr. Kivisari?
Yes, Your Honor.
And I'll be getting the nully on the bond violation. All right. Anything else we can cover today?
As to his bond, Your Honor, will it be reinstated?
Let me see what I have here. All right, I revoked, I had a lodge on that. In respect to the matter, I have some concerns. I'm gonna set bond. I'm not gonna release him on PR based on, one, his prior criminal history here. He's been in a lot of trouble in the last number of years. Two, he had a .10 on the PBT for the bond violation. And alcohol is an issue for Mr. Gerwig. It's been a repeated issue. The underlying nature is of concern. So even though they're dismissing the bond violation, I had talked to him just 2 days beforehand about what was going to happen if he violated his bond, maybe 1 day before. Anyway, Mr. Gerwig does not seem to have much concern for court orders, so he's not going to be released PR. I'm going to set bond at 5,000 cash surety, 10%. And Mr. Gerwig, I can assure you, if there's another bond violation, you're gonna be sitting in jail. There's not gonna be any release. Am I clear?
Okay, yep.
All right. Anything else?
No, no.
All right, thank you. All right, have a good day. Thanks to the jail. We'll call you later when we need you. Officer. All right, we'll start with Mr. Gerwig then. All right, people of the state of Michigan versus Joseph Gerwig, 237768 SM. Mr. Gerwig appears from the Dickinson County Jail. His attorney is David Kivisari. Mr. Kivisari, I can see the corner of your shoulder. You're over there with him. Is that correct?
Yep.
There you are. All
I'm
right.
here, Your Honor. It's not a wide angle screen here, so.
All right, Attorney David Kivisari appears with Mr. Gerwig from the Dickinson County Jail. The prosecution does not appear this afternoon of their own choosing. We are set for sentencing this afternoon on this false report of a misdemeanor conviction. In respect to the matter, a pre-sentence report has been completed. Have you had a chance to review that with Mr. Gerwig then, Mr. Kivisari?
Yes, we have reviewed it, Your Honor.
Is there anything delineated there of a factual nature that doesn't appear to you to be accurate?
No, Your Honor. However, along those lines, one correction that needs to be made to the record as noted here is Mr. Gerwig's middle name is spelled Louis, and I believe there may be some documents in the file that have his name misspelled. Lisa Richards and I agree that would be stipulated. I know she's not there today, but we had agreed that should be stipulated to as a minor matter.
Thank you. I note from your appearance, you do have it spelled correctly. The prosecutor's office on the complaint has it incorrect. So we will make a notation for the record that it should be Louis as opposed to Lewis by stipulation of the parties. All right, then, in respect to the matter, the pre-sentence report, I don't think reflects a middle name, but I've corrected that on the complaint. Is there anything else with the pre-sentence report that does not appear accurate to you, Mr. Kivisari?
No, Your Honor.
Is there anything you'd like to say then on behalf of Mr. Gerwig before the court imposes sentence?
Yes, Your Honor, I would. This is very concerning. As Mr. Gerwig's attorney and his counselor, I'm very concerned about what's going on with him and how concerned with the fact that he keeps ending up in here and can't seem to extract himself from the situation involving his ex-wife. And I do agree that this is probably the safest thing for him to be doing right now is being away from it all. But I do think it's of the utmost importance that he be afforded an opportunity to get some serious counseling to address not just his alcohol issues, but everything else that might be going on with him that is causing him to act out. I've never seen a bad, I've never seen myself any indicators of bad behavior, but obviously he lands himself in here. And he has done so time and again now recently. So I understand the recommendation. I would just be asking the court to consider also including some sort of mandatory counseling for him so that we can try to make him better. But I do agree that generally speaking, what we have here is probably for the best at the moment.
All right, thank you, Mr. Kivisari. Mr. Gerwig, do you need a moment to collect yourself before I ask you if you want to say anything?
No, Your Honor.
Well, Mr. Gerwig, this is your opportunity if you wish to say anything before the court imposes sentence.
No.
No? All right, Mr. Gerwig. Well, I don't think I have to tell you that your decision-making was wrong in respect to this matter, and you've continued to compound it with 2 bond violations. essentially alcohol, I think, is the driving factor here. It makes you lose your inhibition and ability to control your rational thought. And then you violate the terms or like in this case, trying to get back at her because you were angry with her that she's apparently moving on in a relationship by calling a false report of a 911 domestic going on at your former significant other's residence. That is wrong on so many levels. One, it's wrong to her. You know that. I know that. It's wrong to the people that live there. They have to be invaded and troubled and interrupted by the police unnecessarily. And then let's talk about the people that might have been in harm's way that you have now distracted the police from serving because you have made a unilateral and selfish choice to use up our limited resources and time with a bogus complaint on 911. That's not appropriate. You know that, I know that. That's dangerous to our community. That will not be tolerated, Mr. Gerwig. And I'm confident that if he had not been drinking, it's probably would not have happened. So I think that you got to take that and live with it and chew on it and sleep on it for a while and figure out how you're going to deal with your alcohol consumption because it's dragging you down, sir. I don't know what else to say. This happened right before Christmas, the 23rd. You had a bond violation on January 5th for contact via Facebook with the protected individual and registering a .107 on a PBT. When you pled to the underlying, the prosecution dismissed the bond violation, but now we're here back again on another bond violation for essentially the same type of thing, drinking and being on the premises again. Mr. Gerwig, that's a no-no, absolutely no-no. And so, Mr. Gerwig, the order of the court for that at this point in time is clear. You've suffered a high BAC in April of 22, an OW impaired in July of 21, and
He didn't suffer a high BAC. He enjoyed every minute of it.
embezzlement in March of 21, an assault and battery in February of 22, and then some older stuff. So these more recent offenses are the direct result of your inability to control your alcohol consumption and your anger and other issues. So basically, sir, I'm not going to put you on probation. And as your attorney has stated, he wishes that you would get into some long-term counseling or something to address these issues so that you don't continue to come back. And I wholeheartedly agree with him. And I see your mom is here in the courtroom as well. She stood by you steadfastly. You got 100 times more than a lot of people going when you've got family members that are willing to stand beside you and help you, Mr. Gerwig, but she can't do it. You have to do it. She can be there to support you. You have to make the decisions not to consume alcohol and to live a life that is law-abiding. So if you want to get into counseling, I highly recommend it. It's not going to be a court order. You should do that. And there are lots of services that are available out in the community. There's services that are available free of charge. I don't know if you've tried North Point to see if you qualify for services over there, but those are all possibilities. There is Smart Recovery, that's free. You can call in online. That's a peer recovery type of group. All of those things are available to you if you want to avail yourself of them. That's really up to you at this point, sir. But if you keep coming back, you're going to keep going to jail. I don't know what else to tell you. The fines and costs on this false report of a misdemeanor are $590. The crime fund fee is $75. The justice system assessment fee is $50. Comes to a total of $715. I'll order a monthly payment commencing 30 days after his release from jail. Mr. Kivisari, Mr. Gerwig, what can you reasonably make on a monthly basis?
Your Honor, it was my understanding that Ms. Gerwig, present in the courtroom today, has the money in full, although I would give her an opportunity to correct me if I'm wrong.
I think part of the problem is the amount of support that mom has given him. She's enabling him to make these bad decisions and bail him out of it. She's going to pay the fines in full right now. he's not being held accountable for his actions. So he's got no incentive to change.
Mrs. Gerwig, did you want input on that?
I have it.
All right, so she says she will pay that in full today. Thank you, ma'am. I'll order that it be paid in full. I'll just put the next 7 days and you can go on down there if you wish after court. All right, I'm going to order 60 days in jail with credit for 9 days served. Mr. Gerwig will be eligible for good time under the sheriff's scheme over there. Mr. Gerwig, I'm going to read you your appeal rights because I don't think you were tuned in when I read them to the rest of the group. If you wish to appeal the sentence of the court today, you can take an appeal to the circuit court. However, that has to be taken within 21 days of today's date, which is the date of sentencing, or as permitted pursuant to Michigan Court Rule 6.625B. If the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer on appeal, you can apply to have a lawyer appointed for you through Michigan Indigent Defense Commission State Appellate Defender Office to see if you qualify for a lawyer on appeal. However, sir, that has to be done within 14 days after your sentencing. Do you understand that advisal, sir?
Yes.
All right, that'll be on the back of your order of sentence. Yours will be yellow and copy. That's down at the bottom, Mr. Gerwig. Your order of sentence, you are responsible for all of it. Everything that's on the left, on the top, anything that's checked. And I will say, and I haven't for the record, that you are to keep the court advised within 7 days of any change of address, phone number, and/or employment until paid in full. Assuming Mrs. Gerwig goes down and pays that today, that obligation ends today. But if for some reason she doesn't, that is a requirement until paid in full. Do you understand that?
Yes.
All right, do you have any questions, Mr. Gerwig?
No.
Mr. Kivisari, anything else?
No, Your Honor.
All right, then, thank you. Good luck to you, Mr. Gerwig. All right, Michael William Boyd versus Christine Doman, 23-00199 SC. Mr. Boyd on this side, Ms. Doman on this side. Be seated, please. Record should reflect Mr. Boyd appears in person, Ms. Doman appears in person. We are in the small claims division of the district court. Mr. Boyd has filed a claim for $1,700, indicating the reasons are to regain possessions as outlined in the written explanation provided. There is attached a one-page typed paper as well as a copy of a piece of paper with some figures and writing indicated on it. In respect to the matter concerning the small claims division, then, let's see, there's an answer. In regard to the matter, then, the defendant has filed numerous documents attached to her answer. The first thing I need to do is advise the parties that you are proceeding in the small claims division. If you choose to proceed in the small claims division, there are 4 rights that you waive, and they are outlined in the initial affidavit. But if you choose to proceed in the small claims division, the claim is limited, or any counterclaim is limited to $6,500 by law. It changed as of the first of the year. It's now up to $7,000. But at the time that you file this, it was $6,500. So you give up the right to claim more than that. If you give up the right to be represented by an attorney, you give up your right to a jury trial, and you give up your right to appeal the judge's decision. If you want to exercise any 1 or 2, 3, 4, or all those rights, you simply file a request or a demand for removal from the small claims division to the general civil division of the district court, where you can exercise any or all of those rights. Now, as well, the small claims division has certain parameters about what it can hear. And to tell you the truth, Mr. Boyd, I was thoroughly confused after I read your complaint. I don't know where you're getting the 1,700, and I don't know if I even have the jurisdiction to hear your matter. So we have a couple of things we need to plod through here. But the first question I have to both of you is first, Mr. Boyd, are you choosing to proceed in the small claims division and waive those 4 rights, or are you wishing that the case be removed to the general division?
I think there was a misunderstanding right off the bat. I'm not seeking any kind of money from Christina. I just, after the possessions.
Well, you have $1,700 here. You said the amount of money claimed, $1,700. And then you said the reasons for the claim are to regain possessions as outlined in the written explanation.
I believe that's what Christine was, the loan between Christine and I.
I didn't file the claim, you filed it. So I'm trying to tell you, I don't understand it. So we're going to have to go through that. But my first question to you is, do you want to proceed in the small claims division, or do you not want to proceed in the
Yes,
small
Your Honor.
claims?
Yes, Your Honor.
And how about you, Ms. Doman?
I would like to. It scares me, but I would like to. I would like to get this matter settled.
Well, I'm not sure I can settle it under the parameters of the small claims division because I don't have any equitable jurisdiction, meaning I don't have the authority to say, well, this is the right thing to do. We should take apart this loan you signed together and do that, because I don't have that power in the district court. That's something that needs to be brought in the circuit court. So I can't quite figure out. You were talking about this loan you signed together. You were co-makers, yet she didn't make any. She's got it in the garage. She won't give it back because it's tied to some other stuff. And you don't agree on numbers on the other stuff, although you've made some payments. I guess I don't really understand what you are seeking to do here today. Why don't you tell me, Mr. Boyd, what all you were hoping to achieve?
In October of 21, we purchased a motorcycle together. I was a primary buyer. She was a co-signer. In October, we wrote, she offered to co-sign for the bike. My $2,500 down payment, and we got.
So I'm just looking for, before we get into it, you haven't been sworn, you're not under testimony. I just want general, concise statements. I want you, Judge, to take apart the title issue. Judge, I want this, that, or the other thing back. What are you seeking to do? What's your overall parameter?
Judge, I've made the payments since October of 21, and I have not touched the bike since. I would like my rights to the bike.
And okay, so you think that I should undo the stuff that you did at the bank, right?
Undo the stuff at the bank?
Well, you're co-owners, right?
It was, yes. It is on, as far as what Harley told me, it was supposed to be a co-signer, but their terminology is co-buyer, yes.
So she's a co-owner and you want her not to be a co-owner anymore. That's the first thing, right?
Yes.
Second thing is you want it back out of her garage, right?
Yes.
What else do you want?
My possessions back.
What possessions?
My firearms.
Anything else?
There was a jacket that was with the motorcycle.
All right, and in a nutshell then, Ms. Doman, what's your position?
What I want leaving this court is protect my credit. I want my name removed as a owner on that motorcycle. I'm thankful that I am an owner, because if I was just a co-signer, I would have no rights to that bike. And the reason I'm holding 4 guns, a jacket, and a knife of Mr. Boyd is some sort of collateral that he will hold good on that loan. Or I've offered to pay that lien off, but he refuses to sign off on the title of the bike. They will not, the title is held by Harley Davidson until the lien is paid off. And I have spoken to them. If I pay off the lien, the title comes to me. And all I need to do is have Mr. Boyd sign off as a seller of the bike on that title. And he is welcome to his belongings back. I have told him in the past, I could care less about the money he owes me. I just want.
So you would be proposing to pay off the lien and keep the motorcycle and give him back his jacket and guns and knife, whatever.
I have.
But that, I just want to,
Yes, that is correct.
And are you in agreement with that?
I've made all the payments since then, including a $2,500.
So that's a no?
No.
All right, so I think you're in the wrong court. I have no authority to redo paperwork and loans and stuff that you guys have signed together. You're gonna need to file this in the circuit court. You guys have made the issue in regard to the matter. I don't have the authority to undo any loan. You've made this with Harley Davidson, even the circuit court. I mean,
This is what you get for playing house.
stuck. You're stuck. You're co-financed together. So the circuit court can't say Harley Davidson, refinance it. Circuit court doesn't have the authority to do that. I don't have the authority to do that. You're both stuck in it together. So the result that you want is you want somehow someone to figure out who should have possession and who should pay for it in the interim time. Right?
Correct, but I have my own bike.
It doesn't matter.
I know.
The bottom line is, this is what you're coming in and asking for. You can't agree on what to do at the Harley Davidson. Nobody can fix that. You two made that mess. The only way that's going to get undone is if you get yourself, and I'm assuming you're having credit problems, that's why you won't go refinance it. What if he refinances it? That's what you want, isn't it?
Yes, I've offered him, I even came today with a contract looking at both ways. If I were to take on the lien and he, for hoping he would agree to that. But in the past, he refuses to sign over. Even if I take on the loan, he refuses.
I would be throwing 2 years of payments, including the down payment, right out the window by just giving up.
Wait a minute. So that doesn't answer the question. Why aren't you refinancing the loan into your name?
Harley will not refinance a motorcycle.
Because of your credit.
No, that is against their policy.
That is incorrect, ma'am.
No,
I don't buy that. But you're stuck nonetheless. Either your credit's too bad or whatever. The bottom line is, I do not have the power.
Harley Davidson will not refinance a motorcycle. I can
Why?
find outside financing. They will not refinance the same bike.
I've done a lot of research.
And what's your position?
I can do it immediately.
They'll let you do it.
Off the lien.
Oh, but you're gonna be paying it off, but you're not gonna be refinanced.
I don't need to. I will.
No, but so you don't know, you haven't asked them if you can refinance. So he could be correct. They won't refinance it.
They would refinance it. For me, I've spoken with Bald Eagle and Marquette. He even gave me what the bike's worth in that.
Where did you buy this bike?
Bull Falls Harley in Wausau.
Okay. All right, well, you got a problem there. Bottom line is, I don't have the authority, I don't have the jurisdiction here to do. You got a contract with Harley Davidson out of Wausau that says you co-owners and you're co-debtors, basically, right?
May I add something? Your
Yes.
Honor? I have been receiving calls 7 days a week, collection letters from Harley Davidson. And every time I message Mr. Boyd, please answer your phone. I'm getting tired of talking to him. He's like, they never call me. But I have them all printed out. I have the letter from Harley. I would really like to leave here today with him choosing one of those options that I have written out. Either I take it on or he take it on. Because this has been going on for over 2 years.
Well,
And when I speak to Harley Davidson on the phone, I ask, how come you're not asking the co-buyer? And they said they cannot reach her also.
I'm gonna do this.
So wait, you're telling them to contact the co-buyer when they do reach you? Meaning you are making her responsible for the payments. So it's her bike now, right?
I'm gonna set this over for a couple of weeks and I'm gonna do some research. Because I don't think I have the authority to do anything for you people. In the meantime, if you want to go to mediation, we can refer you. If you think a third-party mediator might help the two of you to come to an agreement, we can refer you to UPCAP for mediation services. Otherwise, you're gonna have to take your case. I'm gonna do some research, but I don't think I have the authority to undo this. Your co-owners, your co-debtors. So what needs to be done at this point? Assuming that, I guess you can talk to Harley Davidson in the meantime, the two of you, if you're serious about trying to get this undone. One saying that Harley can't get a hold of them, the other one saying Harley can't get a hold of them. You both should be calling them. You both should be trying to figure out if you can undo this. She's saying, basically, she wants her name off of the debt.
Correct.
And you're saying if he gets your name off of the debt,
He can have his collateral back, no problem.
you just want
The
out.
reason I'm keeping it is because if he had the bike and wasn't paying, I would have,
So if he refinances somehow to get you off of that debt, that's all you're seeking.
I've been asking that for 2 years.
That's all you're seeking.
Yes.
Well, that's a pretty easy goal between now and when you come back. She's not asking for money.
I've even offered, I'll excuse all the money you owe me, I gave him use of a credit card, I have all proof that he owes me that money. And I'm willing to just walk away from that as making a poor judgment. And I want this done. This is wreaking, they're calling my work. I have letters from work. It is getting disturbing. Because he won't release it.
Isn't that also a co-buyer's obligation?
I was not.
Well, you guys got a mess. So I'm gonna do some research, or you can take it over to the circuit court and figure it out over there.
Can I ask, without my agreeing to it, she offered me a place to stay as I tried to start a new job here in Sagola, Michigan. I asked her, okay, if I stay there, can I bring some of my belongings? Without my consent, I called her up one day and asked her how she's doing. And she says, I'm changing the locks on the doors. You're out. And I've not seen my possession since. It's had nothing to do with a motorcycle.
And what do you want me to do?
I would like my firearms back.
Well, we're not having a trial on that here today, Mr. Lundberg. Excuse me, Mr. Boyd, and you haven't filed that type of a lawsuit. You
Yes.
filed a lawsuit for $1,700. That's what your lawsuit says.
No.
Well, then you didn't file the right type of lawsuit. So you want to be your own lawyer, you be your own lawyer, but this is not the type of lawsuit. You did not file a lawsuit for return of items. Well, I'm sorry, sir, and I can't give out legal advice. So you may do well to go see a lawyer and try to get this unraveled. You guys got yourself in deep. And the bottom line is, Mr. Boyd, she's a co-owner. You are co-owners, you are co-debtors. So she could jump on that Harley and ride it till doomsday. You guys both have the same right to it. You both owe the same money to it. So you may want to cry all day long, but you signed the debt.
Right.
Does it mean anything that I've made every payment on this so far?
I'm not gonna,
Does that mean anything?
it doesn't to me today. Not at all.
I would like to go over then to district court. I was advised.
All right. So then I'm going to have you go down to the window in 5 steps down to the right. And you want to do a demand order and removal to from the small claims division to the general civil division.
I wrote it down. I said, I was told to ask to remove the case to the general division of the
Yes,
district.
yes, yes. That's what I said in the beginning. That was the advisal. That's all right. So that's what we're gonna do. There's a form for that. And I'm gonna send you down to the window down there, 5 steps down to the right, Miss Anderson. And then you're gonna have to mail a copy of that form to Mr. Boyd. Mr. Boyd, that form will tell you, you have 14 days to file a proper answer to the, well, you filed an answer. If you file any kind of an amended, or if you file any kind of a counter complaint, then he has 14 days upon which to file that answer. In the meantime, then we're gonna set this for a pretrial conference. We're gonna set it out approximately 6 weeks. I'm going to do some research in the meantime. And
Something.
you may.
He could it's like 4,300 the last time I talked to Harley Davidson. He could gain refinancing for that anywhere.
I don't know what the issue is as far as what his position is or why he's doing what he's doing as far as
He's done it to a past girlfriend. I have all her text messages.
and I'm not getting into that today. So you're saying 4,300, you heard it here today, Mr. Boyd. If you get that refinanced, she's moving on. She'll give you your belongings. She's not asking for any debt at this point. Whether that changes once she gets a lawyer on board, et cetera, I don't know. Anything's bound to change. You can file amended pleadings, you can file countersuits, you can do whatever you want. But the case is removed from the small claims division to the general civil division upon you getting that form filled out. I'll sign the order. You'll get a copy of the order. And what do we have roughly?
Tuesday, February 20th at 10 a.m.
All right, Tuesday, February 20th at 10 a.m. for pretrial conference. That's 2024 at 10 a.m. Central for pretrial conference. We'll give that to you in writing here today. Make sure you go down and fill out that form. All right, then we'll be off the record. From the Dickinson County Jail via Zoom. His attorney is Alex Berger, who appears via Zoom. The prosecution does not appear for the arraignment of their own choosing. We're set today for an arraignment on a bond violation. Mr. Horner, tell me your full legal name, please.
Brandon Michael Horner.
All right, Mr. Horner, I have a bond violation hearing arraignment and waiver form with your signature. Did you understand
ma'am.
all of the rights? Did you understand all of the rights contained in this form?
Yes, Your Honor.
All right, then, Mr. Berger, did you have a chance to go over the nature of the allegation and the maximum penalty with your client?
I did, Your Honor.
And does he waive the formal reading, or shall I read it aloud?
He would waive the formal reading, Your Honor.
All right, and what is his plea?
His plea is guilty, Your Honor.
All right, so Mr. Horner, is that correct? You're going to plead guilty to violating your bond by drinking?
Yes, Your Honor.
All right, Mr. Horner, I want to go over some rights that you have with you first. Do you understand, Mr. Horner, that the allegation is that you were drinking alcohol and registered a 0.05 on a preliminary breath test? Contrary
Yes,
to
Your
the
Honor.
terms of, all right, so the terms of your bond were set on September 9th of 2023. They required that you not consume alcohol. Do you agree with that?
Yes, Your Honor. Yes, Your Honor. I made a really big mistake yesterday.
All right, so the maximum penalty that you face for violating your bond is up to 93 days in jail and or up to a $7,500 fine. Do you understand the nature of the allegation and the maximum penalties you face on conviction?
Yes, Your Honor. I understand.
All right, so Mr. Horner, you are entitled to an open court or a contested type of a hearing if you want to challenge the truth of the allegation that you violated your bond by drinking. Do you understand you're entitled to that hearing?
Yes, Your Honor.
And do you understand that if you chose to have a hearing instead of pleading guilty, you could exercise each of the hearing rights that are listed in this bond violation form that you signed?
Yes, Your Honor. I understand.
All right, to the allegation that you were drinking alcohol in violation of your bond, what is your plea?
Guilty, Your Honor.
Mr. Horner, before I accept that guilty plea, then I want to make sure the rights you're giving up in abundance. You understand then by pleading guilty, you're not going to exercise any of the hearing rights and there's not going to be that contested type of hearing.
Yes, Your Honor. I understand.
And do you understand the court is free to impose any sentence that the court feels is appropriate up to the maximum provided by law?
Yes, Your Honor. I understand.
Understanding that and everything else I've gone over here with you, Mr. Horner, does it remain your intention to plead guilty?
Yes, Your Honor.
All right, then. Has anybody promised you anything in order to get you to plead guilty?
No, Your Honor.
Has anybody forced you, coerced you, or threatened you in any way to get you to plead guilty?
No, Your Honor.
Anybody tell you the courts would simply be more lenient with you if you pled guilty?
No, Your Honor.
Are you pleading guilty freely, voluntarily, and understandingly?
Yes, Your Honor, I am.
All right, Mr. Horner, tell the court in your own words how you violated your bond.
Yesterday was our Christmas party at work. I work at Greenleafs. We went in, me and my girlfriend. We were there maybe 2 hours. I had a shot and started drinking a beer. Two officers walked in. This was about 3:45, 3:30, asked me to come outside with them. I put my beer down. I said, no problem. I went outside with them. We talked for about 10 minutes and then they did a breathalyzer. I blew .05 and they put me in handcuffs and brought me to jail, Your Honor.
All right, then.
Somebody had it out for you. You were at a work party and two officers just strolled in and took you out for a PBT? Yeah, somebody wanted you arrested.
In regard to the matter, the court's going to take judicial notice of the terms of your bond that were put into place back in September of this year, specifically September 20th. You were not to possess, consume, or purchase alcohol. You were not to be in establishments that sold alcohol unless we amended that. Did we amend that portion of the bond, Mr.?
Yeah. Yes, Your Honor.
Okay.
Because I
don't
work at
remember that.
Greenleaf's.
Because you work at Greenleaf's. All right, but
That's
you
all
still
racist.
knew you weren't supposed to be consuming alcohol, right?
Yes, ma'am. I made a big mistake yesterday.
All right, then, in regard to the matter, I'm taking judicial notice of the terms of the bond, terms of the amended bond, and his statements as well. The results of the breath test were .05, according to the police report. I think that that's a sufficient factual basis. Are you satisfied with the factual basis on behalf of your client then, Mr. Berger?
Yes, Your Honor.
Are you aware of any promises, threats, or inducements in order to get Mr. Horner to plead guilty that have not been placed on the record?
No, Your Honor.
And do you believe the court's complied with the taking of pleas under MCR 6.610, Mr. Berger?
I do.
All right, Mr. Horner, I am going to find that you've made out the elements of the bond violation. I'm also finding your plea has been made freely, voluntarily, and understandingly. I will accept your plea of guilty. We're going to set this matter for sentencing at the same time as the pretrial conference that's presently set for January 17th at 3 p.m. In the meantime,
Honor.
did you wish to be heard on bond?
Yes, Your Honor, we did.
Go ahead.
Thank you, Your Honor. I know that the court has convicted my client of criminal contempt for violation of the terms and condition of his bond. I think that in terms of releasing him on bond, the facts that the court should consider is he's gainfully employed. He's a resident of this community. And he is currently scheduled for trial on the underlying offense, and by all appearances, that trial will go forward. If he's released on bond, it'll better help him to able to participate in preparation for the defense of that case. Additionally, he's been a good pretrial release person, with the exception of this slip up. And we don't know why law enforcement were called, but I imagine that he's under pretty close surveillance by various other individuals based on this. And Your Honor, I think it speaks to his candor and how seriously he takes this. When law enforcement came, he didn't react aggressively, negatively, belligerently. He was cooperative, and the police report reflects that. And today in court, Your Honor, he has been he could have set this for a contested matter, but he elected on his own to admit what he did and admit that he knew it was wrong. And I think that speaks to him being a good candidate for pretrial release. I would ask that he be put on an OR bond, same terms and conditions as before. And we will deal with the penalty for this violation at the sentencing. Thank you.
Well, I have some issues going on here. One, he said he went to he's not charged with violating the terms of the bond by being in contact with the victim, but he said out loud on the record that he was at the party with his girlfriend, who is the victim of the case, and
It's my new girlfriend.
This is your new girlfriend. All
Yes,
right.
Your
Yes,
Honor.
Your Honor.
That would be his ex-girlfriend, the one that
All
is the
right.
alleged victim.
Who's the new girlfriend then, Mr.
Lena
Horner?
Zimmerman. She was in court with me the last time I came to see you.
Oh my, he moved on quickly. I think I have a suspicion of who called and turned him in.
All
At the
right.
last hearing.
Well, Mr. Horner, another concern I have then, different concern, is the fact that I gave you an opportunity to stay employed at Greenleafs. I amended your bond to allow you to go in places where they serve alcohol, and it feels kind of like a slap in the face today for you to go to the party. One, it was a party, it wasn't your time of employment. Your bond amendment was that you were to go there only during your hours of employment and not while Miss Congdon was there. I don't know if Miss Congdon is an employee there is still, or if she was there at the time of the party, but that could be a double whammy. So to me, you're not really taking the liberties that have been given to you very seriously. So, Mr. Horner, I am telling you, you're skating on super, super, super thin ice right now. I'm going to reinstate a bond, really against my better judgment here. But you've been truthful. You've sat in jail for 2 days so far. Hopefully that's sending a message across. Because if there's any more violations, I don't care how inconvenient it is for you and your counsel to prepare for trial while you're sitting in the jail, you're going to leave me no alternative, Mr. Horner. The ball's
I
in your
understand,
court.
Your Honor. I understand.
I'll set a $1,000 PR bond on the bond violation. Sentencing at the same time as a pretrial conference, the 17th. You have the dedicated 2 days of trial. Those have been set aside. So, you know, if you're not going to use them, I need to know. If you're using them, like I said, it's all dedicated to you. The jury summons and questionnaires will be going out shortly, Mr. Berger. Anything else then today, Mr. Berger?
No, Your Honor, I don't believe so. Thank you.
All right, your bond terms remain in place then, Mr. Horner. Any questions?
I'm still allowed to go to work tomorrow.
Yes,
Your Honor?
I'm telling
Okay.
you.
Okay,
Appreciate
thank you,
the
Your
fact.
Honor. Thank you,
Yes.
Your Honor.
All right, we're gonna go off the record for a moment.
Your Honor, may I be excused?
You may. All right, can you hear me, Miss Larson? Oh, can't hear you over there though, I'm afraid. All right, now I can hear you. Thank you. All right, people of the state of Michigan versus Cassandra Marie Larson. This is file 247811FY. Ms. Larson appears via video Zoom from the Dickinson County Jail. Counsel at first appearance is Abby Anderson, who appears via video Zoom. The prosecution does not appear today of their own choosing. We're here for an initial appearance on a felony complaint. In respect to the matter, then, Ms. Larson, would you tell me your full legal name, please?
Cassandra Marie Larson.
All right, thank you. Ms. Larson, I do have an advice of rights with your signature. Did you understand all of the rights contained in that form before you signed it?
Yes, ma'am.
All right, thank you. Ms. Anderson, if you would, please.
Thank you, Your Honor. I did discuss the allegations as well as the maximum possible penalty with Ms. Larson. She indicated she understood as well as understanding her rights. She would waive the reading. She did request assigned counsel. Mr. Jespin has been assigned by Ms. Mashik Lasala. We would ask to address the issue of bond in this case.
All right, thank you. In regard to the matter, then, we will set the following court dates. A probable cause conference with the magistrate on February 26th at 10 a.m. and a preliminary examination March 4th at 10 a.m. In respect to the matter, then, Ms. Larson, I want to explain to you what it means to sign a waiver of extradition. The lawyer probably already went over it with you, but I'm going to again for the record. And let me start by saying, so long as you come back to court voluntarily for all of your court appearances, this does not become an issue. But let's just say, for example, you went to Wisconsin or some other state and didn't come back to your court date here for this case. Normally, you're entitled to what's called an extradition hearing before you would be returned to Michigan. The purpose of an extradition hearing allows you to challenge the legality of your arrest and return to Michigan to face the case that you didn't come back to court voluntarily for. So with under an extradition hearing umbrella, for example, you have the right to an open court hearing. You have the right to have a lawyer represent you at an extradition hearing. And if you don't have enough money and you're indigent, one is assigned for you by the state. You have the right to demand issuance and service of a Michigan governor's warrant. You have the right to obtain a document called a writ of habeas corpus. Like I said, all to challenge the legality of your arrest and return to Michigan. When you sign a waiver of extradition, on the other hand, if you don't come back to court, when eventually you do get apprehended, you would return directly with the officials from Michigan without that type of a hearing. Do you understand then what it means to sign a waiver of extradition?
Yes, ma'am.
All right, thank you. All right, then, Ms. Anderson on bond.
Thank you, Your Honor. Miss Larson does reside with her mother in Niagara, Wisconsin. She does have a P.O. box in Kingsford for her mail, but we would ask that she have permission to travel freely between Michigan and Wisconsin. She has pending court matters in Wisconsin and medical appointments as well. Miss Larson suffered a traumatic brain injury in August of last year, so she is unable to work, but it's my understanding that her mother is her primary caretaker and provides nearly 24-hour care for Cassandra. She does have upcoming medical appointments and rescheduled appointments. Miss Larson didn't know the date. She indicated her mother may have that information with her. I would note, Your Honor, she does not have any prior convictions that I am aware of. She does have pending matters in Wisconsin, and the documentation appears that she may have missed some court proceedings while she was recovering from that traumatic brain injury, but all court records I've been able to ascertain indicate that her attorneys were able to speak on her behalf and provide medical documentation. Your Honor, Ms. Larson is wholly indigent. She is still unable to work for at least another 2 months. I would ask that the court very strongly consider a PR bond. It is clear when the police released her, they did not deem her a threat to the public. I don't believe, with the assistance of her mother, that she is at risk of non-appearance. If the court is inclined to set a cash bond, I would ask that it not exceed $2,500, cash surety 10%. As her mother will have to help her post that. Thank you.
Thank you. All right, in regard to Ms. Larson, this is what I've been able to ascertain at this point in time. I saw Ms. Larson a couple of years ago. It was in 2022 before she was bound over to the circuit court on a case that's pending over in the 41st Circuit Court and has been pending since. Looks like there was a felony bind over in October of 2022. There's been numerous bond violations filed in that matter. I think they're up to number 6 from what I can see here over the course of time. Most recently in regard, and she did do some time in between on certain bond violations. It looks like in June of 23, she was sentenced to 15 days jail, credit for 15 days served. In regard to the matter, then she was sentenced to 25 days jail in July of 2023 when she pled no contest to a different bond violation. The jury trials have been canceled. Bond violation arraignment on bond violation number 4 was held in August. It says here in the record that number 5 is not being pursued by the PA. It looks like a number 6 has been filed, although it doesn't have in the Register of Actions an actual filing date on it. However, it does indicate here in November 6th of 2023, due to motorcycle accident, order to complete a competency exam to be completed, PA to submit order, matter adjourned until the report back from the forensic center.
Hey, I think we know who bought the last guy's Harley.
Then there was an arraignment January 30th of 2024 on bond violation 4 and 6. January 31st, a motion to revoke bond, same day order revoking bond. In regard to the matter, then that apparently is pending the competency evaluation. So that offense was pending from 2022. Concerning what has gone on in the meantime then, which is of concern to me, in addition to apparently some kind of motorcycle accident that has resulted in some kind of a traumatic brain injury. I see 2 open cases in Wisconsin. One of them has a filing date of April 18th of 2023 in Racine County. It appears Mr. Schulke is handling that matter as well. And that case is set for status conference on March 8th of 2024. There is a status conference in the status conference that was last fall, October 13th of 2023. There's indication in the text that the defense requests to set for a later or a status later, as there may be doubts as to the defendant's competency. It was set for January 26th at 9 a.m. and then apparently moved to March. Concerning that matter, then there was a waiver of the preliminary examination and an agreement for bind over. At that time, which was January 19th of 2023, Ms. Larson was in custody from the Dickinson County Jail. So that is pending with the underlying charges, which were a second one then. So she has one in circuit right now from 2022. This is April of 2023. Possession of narcotic drugs, party to a crime, felony, possession of methamphetamine, party to a crime, felony, possession of THC, misdemeanor, and possession of, as a party to a crime, I should say, and possession of drug paraphernalia, party to a crime, misdemeanor. And then we have another one that was just filed in the Forest County Jail in Wisconsin, 2024, with the date of offense or the filing date being January 29th of 2024. Likewise, felony possession with intent to deliver narcotics, felony possession with intent to deliver amphetamine, methamphetamine. But
can you just keep her in Michigan and stop letting her come back to Wisconsin? Please? We don't need that in our state.
Between 3 and 10 grams. Misdemeanor possession of a controlled substance, misdemeanor possession of drug paraphernalia, felony possession of an illegal article, felony bail jumping. In regard to the matter, the offense date being January 11th of 2024. This one has a bond that's been posted. I can see from the history of the events that
she needs to stop doing meth. I mean, that'd be where I'd start. She's all yours, Jerry. All yours, buddy.
Miss Larson's mother, who was also present here in court, I should note for the record, appeared in that matter, had conversation with the judge, made statements in regard to Miss Larson's health condition. The court reduced the bond in that case from $5,000 to $2,500 cash. And then that is what was posted in that matter. Evidently, she finds herself back here on this matter now. The offense date being 12/17 of 2023. It was authorized on January 31st of 2024 by the prosecuting attorney's office. So she's got a run going. This is the date of offense before the Forest County case, after Racine County, after the present bind over. But again, same type of events and now a fourth date of offense. So for those reasons, I do not believe that a personal recognizance bond is appropriate. In regard to the matter, then she's pending competency evaluations. That case is at a standstill. There does not appear to have been any type of rehabilitative efforts, even if she does have a prior criminal history. Nothing has been brought forward today to substantiate the record. It appears rather that everything is still pending, and if there are to be any rehabilitative measures entered by way of a judgment of sentence, nothing has been entered and everything is still pending. For those reasons and the other reasons under the court rule, it is not appropriate to release her on a personal recognizance bond. I'm going to require she sign a waiver of extradition as a condition of her release. In respect to that matter, then so long as she does, I will allow her to go back and forth between Michigan and Wisconsin for residency, court appearances, medical treatment, family visitation. You are not to purchase, possess, or consume alcohol or non-prescribed controlled substances. Ms. Larson, you are subject to random PBTs and drug screens. Don't go into businesses that sell alcohol for use inside, such as a bar or a tavern. Ms. Anderson, do you know if there's a request for the use of medicinal marijuana?
Your Honor, I believe Ms. Larson resides in Wisconsin, so she would not have a Michigan medical marijuana card.
All right, is that right, Ms. Larson?
Oh, yeah, I don't have one anymore, no.
All right, then, right now, medicinal as well as medical, as well as recreational marijuana use and possession are prohibited unless or until further order of the court. So if that changes, you talk to your lawyer.
Okay,
If you relocate for any reason, you must provide the court with an updated address and phone number within 7 days of any change.
okay,
All right, then, the last condition of your release is that you are subject, let me find it. To ensure compliance with bond conditions, you are subject to search of your person, property, and electronic devices, including providing passwords or passcodes for electronic devices without the need for a search warrant if there is a reasonable suspicion to believe that you are in violation of a term or condition of your bond. In respect to the amount of the bond, and the reason I'm entering that is for the reasons stated on the record. If they are able to justify, the police, for example, justify a reasonable suspicion that she is in violation of any of these conditions concerning abstinence from drugs and other controlled substances, then I am finding that it is reasonable in regard to the condition, even though it is not obviously subject to a search warrant. I'm putting that as a condition of her bond release for the reasons stated on the record. In respect to the amount of the bond, I am going to set that at the following. I'm going to set that at 7,500 cash surety, 10%.
Your Honor, may I
So, Ms.
clarify one? Oh, I'm sorry.
Yeah, go ahead, Ms. Anderson.
Thank you. Your Honor, I'm not sure if I heard correctly. Did the court indicate that the circuit court revoked bond?
Well, I was reading the JIS. Let me read that. There we go. And that's why it took me so long to get out here. It's very lengthy. It's 8 pages. But it says here, ex parte motion to revoke bond, January 31st. I don't know if that came in from Great Lakes, or I don't know how that was posted, quite frankly. I don't have that file anymore, that part of the file. And then it says 1/31/2024, order revoking defendant's bond. Then it has 2/1/24, motion in order to show cause, motion affidavit and or order to show cause. And then here it is, 2/12/24 miscellaneous. Notice of cancellation of bond and verification of custody, Pam Little. End of summary.
Thank you. So I would just advise Ms. Larson not to post a bond in this case until she knows if she can bond out in the circuit court matter. And Your Honor, for the record, we would object to the search condition as an unreasonable search under the Fourth Amendment.
All right, thank you. So noted for the record. I've set the bond, the conditions. Ms. Larson, you will get all of that in writing, including your court dates and a business card from your lawyer. If you bond out in the meantime, make sure you get in touch with her. And if you do not bond out, she will be in touch with you within 3 business days of today's date. All right. Do you have any questions, Ms. Larson?
how do I go about getting the other one to, what do I have to do about the other bond.
I can't give you any legal advice, Ms. Larson. You'll have to speak with your lawyer about that. Judges aren't permitted to give out legal advice, and that's not my case. That's in front of
All right,
Judge Nina Mia at this point. That's all right. So, yeah, I would talk to your felony lawyer, whoever that is. Who's her do you know who her felony lawyer is, Miss Anderson?
I do not. I was unaware
It's
that she had a
Shoki.
pending case.
It's Shoki. That's who you need to talk to.
Okay.
All righty then. Thank you. Have a good day. We'll be off the record. Thanks to the.
I must say, I don't think that I've ever heard a judge order the right to search someone's cell phone as part of their bond conditions. That was new to me. That's the first time I've heard that one. I'm not saying it's a bad thing, especially not when she's clearly trafficking in some very dangerous substances. But I've never heard of that. I really like Judge Lacoste. I miss her. I wish she still streamed. Really? I mean, I can see that if they're running a ring or something like that. Makes sense. What's what all about? What'd I miss? Who is licking? Oh, it's clean already. Jeez Louise. I gave her the, I had a glass plate that I was giving the cats wet food in, and I'm letting Ava, clean the plate out. And she was being very loud about it. Hey, what? What? You attention hog. I took you away from the dish, and now you gotta have pets. I see how you are. How about I give you a dog treat? Good girl. Oh, well, because she was dealing drugs. So, if the cops suspect her of dealing again, they have a right to go through her phone and see who she's selling to and buying from. I saw that. Thank you so much, Jerry. The animals really appreciate it. All of them do. Ava likes them because every once in a while, Earl will allow a little bit to fall so that Ava can get it. Earl's smart. He really does. He helps the other ones out. He's got their back on lots of stuff. I'm sorry. I've only been on for 2 hours. I love you, though. Good, Joey. I am so glad to hear that. See, all of us praying. I'm really glad that the tests are okay now. I have to. She's a chunky butt too. She's a big girl, and like I said last night, she already takes up the whole bed. I need some of that bed. All right, guys, thank you so much for coming and hanging out with me. I had a lot of fun with Judge Lacoste and you guys. That was great. I really, really like her as a judge. And she had some cases there tonight that were just refreshing to see some real Michigan accountability for once. I wonder if she's still a judge or not. I'm not sure. But it's Michigan, Washington, you don't see accountability as often as you'd like. And she was a lay the hammer down kind of gal. I liked it. Oh, I love you too. I love all of you. Yes, and to all of my fellow Midwesterners, be safe, please. Don't drive. It sucks out there. It's ice under the snow. It may look pretty. Just admire it from your door. Oh, good. I like that. Even though she's not streaming anymore, I really like to know that she's still a judge because I'm sure she's still continuing her accountability lessons and telling defendants that they need to go back to kindergarten and learn basic social skills. Oh, that was probably my favorite part. It would have been even better if she had a box of crayons to give to him to fill out his paperwork with. Oh, okay, so remember my daughters and my Christmas tradition. We order Chinese food for delivery. That's every year. I had my fortune cookie today. Come on. I'm trying, guys. There. Your positive energy will attract success in April. That just seemed so appropriate. I love it. I love this one. Lucky numbers 7, 13, 5, 42, 11, and 44. That's 6 numbers. I think you need 7 for that Mega Millions or whatever. That's up to like 1.5 billion. Well, my birthday's the 12th. But there's already 11 and 13. What are the chances that 11, 12, and 13 would all be drawn? Somebody should go get a lottery ticket with those numbers. It does not, Jerry. Only in your dreams. I love it. I love it so much. Oh, congratulations to them. That's great. I'm happy to hear that. I was kind of thinking that, like, all of a sudden, like 8 people would win it at once and it would have to be split, and you know how that goes. But that's so great. Their life's gonna change. That's amazing. All right, guys. Now that 1.8 billion. Wow. That's so great. I'm really happy for them. I am. I hope that they can use it for a lot of good things for their family. I hope it changes their lives for the better. All right. Thank you guys so much. I really do love every one of you. Thank you for being here. Be safe, be well, sleep sweet, and much love.